Welcome to everyone, those of you in person and those of you online, from Geneva, from Madrid. Welcome everyone to the first industry inside of the semester. With us today we have Xavier Vilaseca. He will be speaking to you today about sports IT and IT law. For those of you who are sports management students and any other student, I hope you enjoy it. I'll leave you with Xavier.
Okay, thank you very much, guys. It's an honor to be here, invited by Geneva Business School. Actually, it's been a pleasure for me to share my thoughts and my previous expertise in the sports industry. And doing it in the Geneva Business School, I think it's quite exciting for me, taking into account that right now, a decade ago, I lived in Geneva for 3 years, and that's basically when I realized more or less that I wanted to liaise and embrace my previous IP and IT expertise in the professional legal side onto the sports business or sports consultancy side. As you will realize during the whole presentation, but not only the presentation, but during this hour or 55 minutes talk that I'd like you to interact as well during the presentation. You will see that there's a direct relationship between the intellectual property field, and especially technology law, related to the sports business. If we go, okay, fantastic. Okay. Just to wrap it up on my intro and my profile, in 2011, late 2011 until late 2014, I was in Geneva working as attaché for the Spanish permanent mission in the World Intellectual Property Organization, and another job that I was related with, I was in a pharmacy related to all the patent and purchase department on that pharmacy in Geneva. At that time, I had the opportunity to go and visit the Olympic International Committee. As you well know, it's based in Lausanne, very close to Geneva, 45 minutes by car or train. Train, I would say, even less. I went as well to the UEFA headquarters in Nyon, even closer from Geneva than Lausanne. And I was able to go to the different UEFA draws, meeting people across the sports industry. And that's when I realized that I wanted to basically go to the second slide here. I don't know, it's one touch changes, no? Yeah, better. So that's when I realized that I could mix my passion as a sports fan through my previous expertise, especially in the legal boutique side for trademark registration and consultancy for different type of industries and companies, and previously as well data protection law, as in Spain started for especially big companies, but as well some medium, small companies. All the assessment and audit on the data protection law side from the organic law in 1999. As you all know, right now we are in another stage, far more. We'll see it in the deeper later on the presentation, but basically that gives you a little bit of my previous background before Geneva. And then I mixed that my passionate sports fan. I play usually football. I used to play basketball as a point guard because otherwise my size doesn't allow to play for another position. I used to play tennis, paddle, some other games, as I'm pretty sure that the majority of the audience as well is passionate, and that's why you are here, or maybe you've got the background of the sports management courses. And then, like I said, that's when I realized that it'll be a good opportunity to try to mix the IP and IT previous expertise, getting to know the sports consultancy side, and then when I come back to Barcelona, by the end of 2014, I started working on a sports consultancy in a variety, a prospect of different projects, especially one project really related to the image or IP side for athletes and content aggregators. Maybe we can discuss later on. And that's when I realized that both domains and both fields have really good match, and we'll see how this works. So if you allow me to make a brief introduction on the basics, on the concepts of the IP to settle a little bit the conversation. I think that this slide really summarizes pretty well the basic concepts of the intellectual property. I would say in a broad level and very, very specific. I mean, we'll go much into detail on every one of the concepts, then it will be only a presentation dedicated for the IP. And this is only to give you a little bit of perspective. Maybe most of you already distinguish this type of concepts, but maybe others are not so familiar. So let me brief you what it says. Sports shoe may be protected by several IP rights. So taking an example of a sports shoe, which could be an item that we could be using in the sports industry, we could have that these sports shoes could be patented and then protect the technology used to develop that shoe. Imagine that there's a specific mechanism that allows the athlete to jump better or doing whatever, that it's new, it's innovative, and it has an application, an industrial application behind that. Then we could be working on patent or utility model. We'll see depending on the type of novelty that brings that specific shoe. Then we got the design that protect the look and feel of that specific shoe. So you could see that maybe it's an imitation of an Adidas shoe because it brings those three straights, but maybe those straights are with a different look and feel. So that's a specific design that will relate consumers, future customers, to relate that design into that specific company or brand or trademark. Then we go to the trademark that distinguish the shoe from similar products and protect the reputation of the shoe. Let's imagine that this is actually, and I don't want to make publicize a specific brand, but let's imagine that this is an Adidas shoe. Then we will consider that it will be interesting for the reputation to have this trademark registration under the name of Adidas or under the name of the brand of the specific shoe. And then we've got the copyright, that it will be the rights of that specific author. In a pair of shoes, what do you think? Is there copyright? Because let me rephrase. I didn't mention that in the intellectual property concept, we've got two concepts. We've got the industrial property and the intellectual property. But basically, for an English speaker, usually even you could distinguish both. Everyone speaks about IP in general, so intellectual property in general. But if we want to be accurate on the definition, we would say that patents, designs, and trademarks are more onto the industrial property side, and they are related to the territory. Right? We go back. It's going. Well, thank you. Just a second. So it would be more focused on the territory and on the copyright protects more what we call the work itself. So there's an author who creates an individual or collective work, and that has to be protected. So how do you think that copyright could be related? Well, maybe you already read it, but just try to give me examples of potential copyrights behind a pair of shoes, sporting shoes. Okay, go ahead.
The logo.
Sorry?
The logo. The logo of the shoe.
It's hard.
The
The logo. But this is that. Don't you think that it's more related on to the trademark side? Because when you talk about the logo, it's when we were calling if the three strikes, it's related to Adidas. Adidas will protect that logo, that corporate image, into the trademark side. So this is more industrial property. Okay.
So for let's look at like a shoe, like Miami.
Yeah. You're talking about the shoe, but what?
Shoe.
Yeah.
The shoe, like let's look at like a Jordan shoe, right?
Yeah.
Like a Jordan Jordan, the Jordan side, that would be trademark.
Yeah, but exactly. So the Jordan shoe with that's a logo that could be a trademark registration.
So the colors
Or the design would be how it's created, the look and feel of the shoe.
So in that context, what would be the copyright?
That's what I'm asking.
The slogan or the message behind the product.
The slogan, we're
Yeah.
getting closer. Anyone else want to go ahead?
Could it be the brand name?
But again, the brand name, I mean, even if it's an ID and then usually it could be implied on the trademark registration because you're gonna say, let's say, following the example that he mentioned, Air Jordan shoes, then the brand name could be registered as a trademark. But again, copyright, we're close on the slogan.
The specific design within the shoe, maybe the insole.
Yeah, but this is the design. This is the look and feel of the shoe. Okay. Yeah. Copyright, and here gives you the one of the examples following what she mentioned about the slogan, protects any artwork and audiovisual creations used to publicize the shoe. So any commercial with an originality of a 1 or 2 minute clip publicizing, showing how is the shoe, that story, that is protected under copyright law because there's some authors, some producers that work to wrap it up into that piece of work, which is the audiovisual content, which is the commercial for Air Jordan, Adidas, whichever the pair of shoes belongs to. Yeah, go ahead.
So let's say there's a new shoe,
Mm-hmm.
they put up a billboard, would that be protected with copyright? Like they put up a billboard with a picture of the new shoe.
Yeah, that specific billboard, how it is created, that could be a piece of art. And then that piece of art or creation, that could be protected under copyright. That could be a good example as well. So we got the slogan, the billboard, so any piece of individual or collective work related to the pair of shoes. So basically, with that analysis, we've got a little bit of an intro about the basics of the IP. We're not gonna get so much into detail because otherwise it would be a session only related to the IP or IT law. But I thought that it was interesting to at least interact with you and go through the different main basic concepts. Okay. Is there any, because I don't see the guys online, sorry guys, pleasure. Is there any question related to that, or we can move forward? So then let's move forward. Once clarified a little bit the main basics, let's go a little bit more onto the specific title of the event today. So we're talking about the evolution of the IP and IT law in the sports industry. But first, we need to understand, how does IP support sport? Okay. So here we've got a list that could summarize pretty well where we can find that evolution on the sports industry for the IP. And let's talk about IP, then the extension of IT we could speak later. But here we see sports event organization. There's IP assets implied in there. You'll see IP rights owners, who owns those rights. Social and economic development.
Sorry, you can keep going. I'm gonna make
Thank
it
you.
bigger for everyone. If you want to keep going, I'll put it in percent so you don't get.
Thank you.
Ahora solo con tab.
Perfect. Thank you. Okay. Much better. So social and economic development, that's a consequence of what intellectual property brings into the sports industry. Broadcasting rights, sponsorship rights, merchandising rights, limitation through exclusivity, and creative and innovative, which this applies to any type of industry that can create new things to evolve in any sector to be more competitive in business terms. Let's try to debate these concepts. Any particular interest on any sports event that you would like to speak about? Anyone? I don't know. Any examples?
The Olympic Games.
Okay, that's great.
Yeah.
So that's a good example. Thank you. So we've got the Olympic Games as a sports, I would say, the major event in the globally in the world sports sector. We could debate whether, if maybe football fans, they will say, for me, World Cup has more impact globally, but I would say that it'll be between World Cup and Olympic Games would be more likely one of the top events over, well, every 4 years. In that case, if we talk about summer games, every 2 years if we combine summer and winter. So we have this event, Olympic Games. Let's talk about Tokyo 2020 in this case. IP rights owners. In this case, who could be on this event, Tokyo 2020, the owner of the IP rights? What do you think? Anyone?
Of the event per se, or?
Yeah, probably in that specific example could be in Tokyo 2020, the Japanese Olympic Committee and all the companies associated onto the Olympic Committee. And obviously the International Olympic Committee then we'll see how it distributes other rights because they've got the ownership of certain rights, as we will see broadcasting rights and sponsorship rights globally. But regionally, there's a question. Yeah, go ahead.
Marwan, if you wanna.
Yeah, and the sponsors too, right? The sponsors own IP rights or no?
Yeah, what do you mean about the sponsors owning IP rights?
Like they have IP rights or not? Like the owners, because they pay to organize the event, right?
Obviously, I mean,
Mm.
basically, on the broadcasting and sponsorship rights, broadcasting is obviously broadcast, TV, all the different sporting events that are taking place in an Olympic Games, which are a great variety. And in terms of the sponsorship, are the global sponsors for the Olympic Games in that specific game, Tokyo 2020. That is.
Yes.
We will see that on those rights, obviously there's an exposure, and this exposure is related to the intellectual property in many ways, and we will see how. But on the sponsorship, I would add that we've got regional sponsors and global sponsors. What does it mean? Well, regional sponsors maybe are more focused on the areas where geographically are taking place that event and or is broadcasted that event, and then those regional sponsors pay because the Olympic Games obviously have major exposure around the world. And global sponsors are the owners of those IP rights is the International Olympic Committee, because obviously that global sponsors renew from time to time the different agreements defending several sponsorship activations to deploy and to exploit commercially all those rights, and having this exposure on TV will bring to the sponsors obviously a way to get more loyalty in the client. We'll see many different things, but basically that would be. So we've got the audiovisual broadcasting TV rights, the sponsorship, the sponsors in different areas that will somehow get exposure from such a major event. But we will have global sponsors and regional sponsors. Then we have merchandising rights. What do you think that could be related with? Or licensing and merchandising rights? This is a direct impact and relationship on the intellectual property sector or industrial property sector.
Does that have to do where and when specific merchandise can be sold?
Yeah, that's really a good approach, because and very interesting in these last games in Tokyo 2020. Well, games were meant to be celebrated in 2020, and finally there was a postponement for COVID-19 reasons, and they weren't so sure if they could be celebrated, if they could taking held somehow in Tokyo for the next year in 2021, so this current year. But finally, the postponement was agreed, and the games took place a couple of months ago. But took place under what name? Under what branding name? Tokyo 2021 or Tokyo 2020?
So I was going to ask, so everything had to change again.
Exactly. There were so many commercial rights involved, and especially in terms of the merchandising, licensing, all the any T-shirts, any material, athlete material, any related on the licensing and merchandising for lots of sponsors, official global, sorry, and regional sponsors everywhere that changing the branding had a direct impact economically, and economically wise, Tokyo already lost a lot of money because of the ticketing side, and logistically it was massive. It was massive, and in the end, the games were meant to be taking help on the 2020, and it made sense to even being a 2021, maintaining the same branding name. So merchandising is more related onto the items that could be sold during the celebration of the Olympic Games. Items such as pens, T-shirts, any other clothing retail industry related to the Tokyo 2020. When we talk about limitation through exclusivity, what do you think that how applies that on the IP? Limitation or boundary through exclusive?
Does that should have to do with like the merchandise itself?
And that's related actually onto the different agreements that are signed between broadcasters, sponsors, maybe related to the licensing and merchandising of the different retail companies that distribute material from the Tokyo 2020 in this case. Usually, obviously, if there's one company, let's say one sponsor, that wants to get exposure, and that company is a beer company or a car company or a betting company, whichever company, but in that area, in that industry, would like to have exclusivity. Because can you imagine that, let's say, and I don't want to publicize any brand, but there's different brands of beers that they have an agreement with Tokyo 2020 globally, that could reduce the exposure, that could be confusing in terms of how the consumers of this sport event would think about those couple of beers, no? Then we would consider if a beer is a good sponsor for a major event related to the sport field, if that's really a connection on the sports side. But as you know, for instance, UEFA Champions League, they've got a beer company for exclusivity, and even if it's related to the sport, that company pays a lot of money to have that exposure. So you will see that we will discuss about the balance of allowing certain sponsors onto the value side of or the impact on such a specific sporting event or not. Now we've got this case here in Spain that all betting companies are banned from being titled sponsorship on the T-shirt, on the kid sponsorships, especially on the T-shirt side, because it is considered from a legal perspective that it's damaging a little bit the image of the values that want to introduce from La Liga and from the competition itself. And this is why it is considered that betting companies are banned from this type of competition. But basically, limitation through exclusivity, it tried to bring the investment, the return of the investment of those sponsors, of those broadcasters, to have exclusivity about that product that they invested in terms of the sponsorship fee that they are, or the broadcasting fee that they are paying for having exclusivity on that territory or specific territory. And creative and innovative, basically that's many things in many different industries. But does anyone dare to give me an example of being creative and innovative in terms of any sport, even in the Tokyo 2020? Any example that you
I just thought of VAR.
VAR introduction in the football sport. That could be a technology application of very innovative in the sport because it wasn't used. No, it's a good example. That could be a good example. But is it not innovative because it applies new technology into the sports and it brings more accuracy on how the referees
It kills doubt, so.
judge the game. Even sometimes there's an interpretation of the game. For instance, I remember last night there was a game that there were 4 penalty kicks. This is quite surprising in terms of a football game, no? But still, they reviewed and maybe they challenged that onto the VAR system, and they confirmed that those decisions. So, fine. Let's go back. Oh, no. So my first, let's say, bullet point or my first approach on the evolution of the IP and IT law in the sports industry relates to, like I was explaining before, on the contractual IP and image rights scope. Okay. So now that we have an approach or have an idea about what are the basics, what are the concepts on the intellectual property, and now that we have approach on how does support the IP onto the sports industry and where are those key assets on the IP, so the sponsorship agreement, broadcasting rights, merchandising, social economic development, creative and innovative, everything is related to the IP and IT law. Let's go onto the contractual IP and image rights scope onto this day or the evolution for the past year, and especially I think that it's good that we think about how for the past 5, 6, 7 years it's constantly changing, and after COVID-19, even we're exploring some other things to take into account of the evolution itself. So, but let's just start about summarizing one of the basics as well on the IP side, which is what are the concept of the image rights. What do you think? How could you define image rights? Anyone?
For example, if you live stream a football game on a site or something, and this site doesn't have the rights to stream this game, this is like legal.
But are you saying about broadcasting the game, or are you talking about?
No, actual game, like they film it, live stream it on the
And
site.
they stream it, and that could be a mechanism of piracy and an infringement of those image rights if they get streaming without having the proper rights. But yeah, that could be an infringement of image rights of those players because they participate in a competition, and that competition has already some broadcasting agreements, and you're talking about an infringement of those broadcasting agreements. So it wouldn't be a direct implication of the image rights, but of course it would be related. Go ahead.
I'm not sure I'm right, but I think image rights are more on the individual. So,
Yes.
like, using Cristiano Ronaldo's face in your campaign, like it's infringement of image rights.
Well, it depends. And why I say that? If this campaign is paid for one of the sponsors and he, Ronaldo or whoever athlete, has this agreement, and part of this sponsorship activation of the agreement is some sort of promotion and shooting and footage for that specific commercial, then it's not an infringement because he will get paid for that. But this is a good call. I mean, obviously, and that's why I'd like to split onto two concepts, because maybe if we would go under the Spanish law, it would be a bit more complex in definitions, and there would be law of honor, intimacy, privacy. So it's a bit difficult to go so much into detail. But under the English law, usually the definition that brings clarity on that is that we'd like to define it as right of privacy versus right of publicity. What do you think would be right of privacy, and what do you think would be right of publicity? If we're talking about image rights of, for instance, as you were saying, Cristiano Ronaldo, Messi, or whoever. But any ideas about what is right of privacy or right of publicity?
Right of privacy could be, for example, if he's in a changing room, changing, that you're not allowed to take images there, or certain other locations like in his house or wherever. And right of publicity would be publicizing the images.
Correct. And it's, okay, the right of privacy, I couldn't define it better. So it's perfectly at his home or in an intimacy area where it's difficult, and over there could be a direct infringement of the image rights of that specific athlete, because there's no it'll be difficult to make the interpretation that there's a sponsorship activation or a consent from the athlete to allow those images to getting publicized. Right of publicity, you were saying you were saying about image rights from that athlete, but commercializing those image rights, no? I guess. More or less. Yeah, but sometimes he could be in a press conference, okay, and he's with a Nike T-shirt. Sometimes, and Cristiano Ronaldo's got a sponsorship agreement with Nike, but imagine that day he forgets and brings an Adidas T-shirt. That could be a direct conflict, and he could have some problems because he's getting exposure. And then he could say, yeah, but I'm not working at that time. Well, yes, you're working because you're giving exposure, you're in a press conference while you're a Man United player. Then now if Man United is with Adidas, we could be mixing other stuff. But what I'm trying to say here is that sometimes, if media or photographers or others get some images in a context whereby Cristiano Ronaldo or whoever athlete is working, and that doesn't mean only on the pitch, but on a sponsorship activation or attending the press, or then we have to understand, even if there's not a tiny clause that says that he will get a fee or specific or not, that it's under right of publicity, and that media or that specific photographer has the right, because it's Cristiano Ronaldo, to publicize that image. Is it clear, more or less? Fantastic. Okay, then in the contract, in the different agreements, right now on the sports industry sector, and more related to the athletes, but not even to the athletes only, but as well onto the club side. We've got something that you all know very well, which are the different social networks or social media. Around 2006-2007, more or less, it started on Facebook a little bit. Well, Facebook in Europe, it was 2004 before, but maybe people started to have some some profile accounts by that time, more or less. Probably anyone in this class still have, maybe you have a Facebook account, but probably you are more used to an Instagram account, or you're using more Instagram than Facebook. Am I right? Probably. Probably. But right now, as you can see, there's a lot of content, and everyone seems that is under the Instagram Reels or under TikTok. And TikTok, probably you talk about 5 years ago, nobody knew about because it didn't exist. Now, the multi-directional community of Twitch interacting in a different way is step forward. Snapchat in the past. There's many social networks. Not so many. Many were obviously they lost track because they didn't bring added value to the youth or even to the community, to the social community. And in the end, social networks they were bringing specific tools for every specific community. So let's think about LinkedIn. Probably is more of the professional part that we're all related with. On Twitter, maybe we will check the news and be informed, but not only Twitter, maybe LinkedIn in some specific parts of whatever industry or interests you have. Facebook and Instagram, maybe it'll be more like gossip from our peers or our friends, no? So every community, maybe TikTok is more to have fun. So every piece of or every social network, it is applied to a specific way of relationship inside that community. And if you take into account those differences, you will see that in Facebook, in Instagram, in LinkedIn, in TikTok, in any of those social networks, there's IP. How? I mean, you give consent, you seize those rights to that specific social network, but you are creating IP. What? How come? So, for instance, this event. If someone posts under LinkedIn that I share, you are giving a piece of work, tiny work, just a picture and summarizing how was that event for you or whatever reason. That specific post, I mean, obviously has not a direct impact under copyright, but it could be considered as copyright if the whole session of today we record it and we sell it to someone else. Obviously, there will have an impact because I would ask Geneva Business School to consent, or at least to consent that possibility. But it's not only that. You were saying before, logos, the exposure of those logos under those different social media channels. The video content, when you create a TikTok video, is a piece of work. Maybe you could discuss whether it's arguably if it's an artwork or not, or if it's a piece of work that contains that uniqueness or originality to be considered as protected under copyright. But for sure, it's a work and it could be protected under copyright. And why do I underline that social media concept? It's because it's in constant evolution, and in the context, it changes the way of communication for all the stakeholders in the industry. So that means the clubs, if they want to get to the young people, they have to start relating onto the specific social networks to get closer to those youngsters. Otherwise, they get lost and they lost the track of being of communicating or addressing the right message to those young people. If we want to inform for some specific, the clubs need to understand what channels they have to use. For the athletes as well. The athletes, if they want to connect with their own fans, they have to do the same. And on the sponsorship activation agreements, it'll be very, very important how you protect the IP rights in terms of term, duration, how the rights and obligations implied in terms of the image rights that you're consenting, intellectual property rights that could derivate of those video contents, etc., etc. So monetization 7-8 years ago was really difficult because we didn't have so much data about how a video content for a content aggregator in the project that I was working with could really monetize under a video posted in YouTube, because they started the programmatic sales. So maybe there was an opportunity there to sell that content to brands, and for every follow and every click onto those videos, you could monetize somehow that specific content. But right now, there's not only that, there's multiple choices. You could sell it to an OTT if it's a very specific and interesting content, and those clips or those pieces of documentary series, for instance, you could sell it to a specific OTT, call it Netflix, HBO, call it anyone, or even very specific related to the sports industry, and that session of those rights, of those copyrights, could have a direct fee or economic compensation for that copyright that is protected under those pieces of series of that work. MRG, it stands for minimum revenue guarantee. Some of these contracts, somehow because of the difficulty to make a good assessment to see that piece of work, what real value it could have, or how can we monetize it as much as possible for both parties, the sponsor and obviously the athlete or the club who stands for that sponsorship activation. It is difficult to assess sometimes. And then there's that concept of minimum revenue guarantee, which gives comfort, or it used to give especially comfort to the athletes or to the clubs, which was, okay, I cannot give you a certainty of how much money we're going to monetize for this project to publicize those video content onto that content aggregator or onto that specific channel that we're publicizing this specific content. But I do an estimation of projection, and I assume that if I pay you, Cristiano Ronaldo, or any other player, X amount of money, I will be covering. I will invest that money to give exposure to my product for sure, but that allow me to get more exposure for other brands, etc., etc. And maybe these type of projects, they were obliged to, even it was an investment which the return was a bit uncertain, but to give a minimum revenue guarantee, an X amount of money in advance. Problem of that is that you have to educate athletes and clubs how to release that content and how to create that content to make it engaging for the fans, to create that fan engagement. And this goes related to my other point here, which is the storyteller. Storytellers is not only in the sports sector, in any industry, but I would say that right now, the way we communicate for the brands, it's explaining a story that gives emotion, that approaches and relates the real values for the individual. And most of the times, even that story is not, it doesn't relate directly to the brand that is endorsing that specific story, but gives value to the property that they are sponsoring. Let's say the Tokyo 2020, and let's say that it's a beer, following the example before, a beer commercial. You have to bring some story that gets emotion for the fans, and then in the end of that story or that commercial, if you really like it, you will be seduced and you will remember the brand, even if it's a beer brand who explains the story which is not directly related to what they produce or they manufacture. It's very important that, and you will see that usually even short clips right now to connect with people, the storytelling is one of the main messages, and you could see that most of these agreements or these contracts, even in the sports industry, go into that direction. They don't specify it has to be a storytelling commercial, what you have to deploy or you're obliged to do, because actually probably it'll be the publisher itself that will try to force the athlete or the clubs to educate them into that direction. Then we got the chief revenue officers. This is a position, a role in the talking more related onto the club side, which is especially after COVID-19 is growing, and this executive has quite a significant power on the institution that represents. How is that? Any ideas of why do you think the chief revenue officers now they've got a significant role, and especially after COVID-19 situation? Any thoughts?
Sleep role in sales, no?
Yeah, that could be an option. That could be a good argument, yes. What else?
The financial instabilities that have been brought by COVID, that the chief revenue officer could give, a sort of stability, or at least like a sort of have revenue inside the company.
Certainly, that's perfectly right. And what revenue streams do you think that are especially affected after the COVID-19 situation?
Fans, having stadiums like fans.
Okay,
Merchandising.
so ticketing is the main one. VIP hospitality, of course. But do you think that affected some other rights as well, or just ticketing?
TV rights, and a bunch of things related with the
TV rights, especially because there was a suspension of several competitions in different sports. In that scenario, the cancellation of those agreements was losing some rights, and there was not a remuneration or a compensation for that for those broadcasters. So obviously had a direct impact. But somehow, for instance, here in Spain, La Liga was able to terminate the competition later, and somehow it was reduced the broadcasting fee, but it was it had not so much impact as it had obviously the ticketing side, but of course broadcasting had a huge impact. But I would say that for the top clubs, if we're talking about football, especially ticketing, VIP hospitality, merchandising, because if there's no games under the stadium, it's difficult to sell t-shirts from Messi, and if Messi leaves, for instance, if we're talking about FCB, then it's more difficult to sell t-shirts under the FCB. To put a brief example. So this is why chief revenue officers, they try to see what are the key revenue streams, and this is why they assess the IP assets very well and try to squeeze it somehow in a way that clubs obtain the maximum amount of remuneration of revenue streams out of those licensing, merchandising, under the social media, under the athlete agreements. That will help a lot on obtaining better revenues for those specific clubs. And there's many other issues, as we pointed out before, the branding name or branding implications of the Tokyo 2020. Thanks.
Someone,
There's a question? Yeah, go ahead.
Carlos?
Yes, doctor, I have a question, please. In case when a team like FC Barcelona, for example, sells the t-shirts, like he has revenue from the t-shirts, all the money and all the revenue goes to the club and to the managers or to the player, to like the player takes commission from this revenue or not? The athlete.
We're talking about selling FC Barcelona t-shirts. What was the question again?
Sorry, I was asking if all the revenue goes to the club or it's divided by the club and La Liga.
About the t-shirts. I mean, we will have to look at it every specific agreement in that case. Now we will have to take a detailed look really carefully the agreement between, in this case, Nike and FC Barcelona, how it is written and how it is constructed in a way of how, in terms of officially those revenues that Barcelona gets from elsewhere, depending on geographically countries where they sell more or less. If there's a percentage for La Liga, and obviously we're sure that there will be a percentage as well for the retail company. But we will have to go, it varies, it's case by case, and it varies from depending on the type of contract that FC Barcelona in this case signed with Nike, which in this specific contract, I would say that Nike right now is trying to sit down with FCB and try to renegotiate the current agreement, because obviously COVID-19 measures and COVID-19 impact have some implications on both sides, for both parties. But this is, I know that maybe doesn't reply your question so much deleted, but it depends on the conditions that are in the specific contract. Is it okay? Yeah, well, we keep going.
Yes.
Yes. Thank you, Maro. We keep going and we switch on to the social media and data protection regulation. I'm gonna skip. I'm not gonna skip, but we've already discussed about social media. I'd like to rephrase a little bit the general definition that we could understand for social media is the collective of online communication channels dedicated to community-based input, we were saying interaction, content sharing, and collaboration. This is one possible definition of social media, but I'm sure that we could find others that could apply as well. Well, as Facebook bought WhatsApp and Instagram, here we've got the first Instagram, Facebook, WhatsApp, Twitter, TikTok, Twitch, LinkedIn, Snapchat, Pinterest, and many others. But these could be the list of the most well-known right now in the globally industry of the social networks. Maybe that could vary from Asia because there's Weibo and there's other social networks, but obviously more or less that could be a good summarized list. Here, social media analytics, we will have to take into account, as maybe in some other data analytics sessions or marketing sessions, you've heard about the CEO and SEM, which basically what allows you is to, onto your own business in whatever sector, and that applies for the sports industry as well, in terms of getting more tracking and more access to the users or consumers of that specific business, you will use some analytics through Google that you will pay some money to have access to those channels, and how your business is positioned on the network. That would help as well to be classified in an upper list onto the Google Analytics. So you've got a way to do it through payment, obviously, and a way that you do it because the content that you're creating is so good, not only in Google, but as well on the different social networks, that is well considered by Google and that specific social network that will help that business to be upper and better positioned into the market. This is something really interesting for clubs. So when clubs sometimes forget about how positioning that specific content, time zones, they want to sell or promote a specific event or any, they have to take into consideration all these variables. And this is why right now professional clubs, they've got obviously many people on the digital side, on the marketing side, trying to connect with social media and in data analytics to really process and to give traction to that specific club. Obviously, or ultimately, if you are FC Barcelona, Man United, Man City, PSG, Real Madrid, all those top clubs, they got already huge access. They've got professional people working on these fields, obviously, but they are so well reputed in the business, in the sports industry, that for them it's easy to do that work because the reputation helped them to have fans and to have access to their specific content. But bear in mind that how you address that content, the consumer or the user will digest it in a way that if you do it properly and if you give good content, it will be much easier to keep growing the number of fans and users and consumers getting into the different websites and social networks. On data protection laws, I would mention a couple of things just because otherwise we could get extended so much, and I think that it's better to get into debate and discussion about risk and mitigation on the COVID-19 for the sports industry. Data protection law, as you know, it relates to our personal data and giving consent or giving access to certain businesses, industries to share those specific data, but obviously, certainly with all the security measures and proper consents under the GDPR, which is the regulation right now in Europe that applies for protection level. In terms of applying that into the sports business, I would say that it's getting more important because after the GDPR sanctions to the big companies, and some sports industry businesses are big companies, are getting more expensive. So it'll be really important, the ITOs, the technology officers or chief officers from the different clubs or institutions in the sports industry to bear in mind to be well regulated in that area. So publicizing or giving access to database from personal data from not only the athletes, but other employees from the club or the company could be a direct infringement of such regulation, or disclosing some data from that agreement, or not, that there's third-party suppliers that could be related with the club that have to have access to some personal data, but the contract could be not signed or not well produced, or for whatever reason there's an infringement because of that. So clubs, they have to be very careful because this is something that is increasing the number of sanctions in different variety of industries in the world of sport. Maybe are not so well known. Maybe we're more. You will have seen some examples on companies, big corporations like Telefonica, or on the banking side, or because obviously there's very sensitive data related with the banking side, or even Google or some other social networks. There's some infringement of the specific regulation, but I must say that maybe clubs are not so conscious about that, and they really have to be concerned that right now they could be perfectly a target. And I've seen sanctions of lower clubs that have given some authorization to local journalists to give personal data, IDs, names, and other specifics from athletes or other employees from the club, and that causes sanction of over 5,000-6,000 euros, which is tiny money for a top club, but I'm talking about really 10 years ago, and for a club which the budget and in terms of it was a really small club here in Spain. So 4,000 or 5,000 euros for that specific club, which was not even a professional club, had a really impact on the business side for them, or the cash flow of the club. So bear in mind that this will increase. I don't want to go so much into the legal exits or legal constraints. I just wanted to point out that aspect. So basically, as we were saying, clubs, athletes, content in social media could be as a sponsorship activation for brands, let's say sponsors, a contractual obligation as a club employee or athlete, or individual image rights for the athlete, depending on the type of content that specific athlete, for instance, is releasing. It could be for a sponsor campaign. It could be as an obligation that on the labor agreement from the athlete and the club could be related with, or there's some C's from the athlete side to the club to release some content or to produce, some content as an obligation. And it could be an individual image right. For instance, he wants to publicize under his Instagram account. Time and performance, that could be a measure to obviously specify the rights and obligations of that type of image rights or IP contract between the athlete and the club. Content remuneration, what we're going to have as an extra fee, or if it's implied on the fee that he gets as a salary. And then commercial exploitation from the athlete and the club's perspective, depending on the type of agreement that we're talking about. Under the data protection analysis, things that could be related, and especially after the COVID-19. Data analysis performance. You know that the clubs, they like to analyze, to test it, to have better professional athletes. They analyze physical performance, health, and many measures that could allow the technology implied on that analysis, allow them to bring some personal data that could be protected under data protection law, but as well, it could be a good measure for the team to perform better. Medical test, obviously, there's sensible data from the athlete specifically there. COVID-19 protocol, now UEFA and other federations and other competitions, they carry out with a protocol to specify some measures. There's a medical officer, there's a specific protocol in every match from the UEFA Champions League or the UEFA Europa League. Future sanctions, as I was pointing out, is not the same sanction that I was referring before about a specific non-professional club 10, 15 years ago giving some data, giving access to some data to a small journal or small paper. Right now, we're talking about in the professional path in the sports industry, we have to be prepared to really have good audit and good compliance on the data protection law, and consent to the third parties allowing access to athletes' personal data. So it's very important how we give that consent if it's under GDPR, which is the regulation in Europe, but we will see, depending on the jurisdiction, what could apply. But in Europe, if we go to the GDPR, it's sufficient to look at how it applies, how it works. And then from every specific country, we'll see the differences on the legal application. Sport transactions. What time is it? This is the last point, because actually the risk and mitigations in terms of after COVID-19, that analysis, it'll be a mix of what we've been discussing throughout the session. And for me, what it is important is that we could try to do some brainstorming in the end to interact and see what risk and mitigations you could see under the COVID-19 after COVID-19, for the sports industry, especially related to the IP. Well, IP assets is key guarantees for clubs, properties, and industry stakeholders. We've got a percentage of the athletes image rights. We've got licensing and merchandising. Some products that could be commercialized from that specific event. We were talking about Tokyo 2020 as an example. The athletes' image rights from the athletes that participate in the Tokyo 2020. Broadcasting rights. And then we'll have, depending on the territory, on the sector, there will be some audiovisual or TV operators, and there will be others. And here in the broadcasting rights, the landscape is an ecosystem that is starting to change a bit, because some OTTs, some other big corporations are like Amazon, like Facebook, are trying to be involved under this ecosystem. That is changing, and that certainly we'll see how it evolves and how it's changing the way you consume sports, because sometimes you just want a highlight of that specific game rather than watching the whole game. So that changes a little bit how we have to, how the consumers behave under that specific product. And then, but that brings other different products related to the main game that could bring other IP rights onto the business or sector. Sponsorship agreements and other potential IP content. For instance, that multi-directional relationship that we were seeing under the Twitch social network. As you well remember, we had an example for the first Messi game under a different T-shirt from FCB. In that case, the first game under the PSG T-shirt. Gerard Piqué bought the rights to from the Twitch channel and broadcasting it through the influencer Ibai Llanos, who and Telecinco bought as a broadcaster the game, could do that analysis and make it under the Twitch channel. This is something really new. This is another content or video or the visual content that has a direct impact on the image rights of the athletes and the sport industry in general. And this is something that it's evolving constantly, and we'll have to analyze as it grows and as it evolves continuously on the ecosystem of the sport industry. Just to bring it under one of my other roles on the sport industry is try to facilitate, and especially after COVID-19, it's very, very important that facilitate or intermediate financial solution to the clubs now that they're struggling to the cash flow needs, because they've been reduced, as we were saying, on the chief revenue officer. The chief financial officer in this case has a balance sheet and P&L, and obviously the fact that the revenue streams have decreased and they have major salary costs based on the big salaries that the professional footballers in that specific obtain. It's really hard to be stable as a club. So some imaginative solutions could be to anticipate assets that the club have under the transfer fees that they get from the players, or even the broadcasting contracts that they have with, in this case, La Liga, because it's centralized La Liga in Spain, and in EPL or English Premier League, etc. On the football financial club management, cash flow management for football clubs can be challenged with the uncertainty that transfer windows produce in the planning of the season. Therefore, clubs often seek factoring of each transfer fee receivables or other revenues to match their liquidity situation. The most common asset to be sold by clubs to lenders are the broadcasting rights. If you're asking about what are receivables, receivables is basically when you agree for the transfer, for the sale of certain player from one club to another club internationally or nationally. You say, let's imagine 20 million. That's the cost of that player. You put in advance maybe 5 million, and then the rest, the 15 million, it's under different installments. Let's imagine it's 21, 22 in this summer window, and they paid 5 to the selling club, and the other 15 are meant to be June 2022, June 2023, and June 2024. 5. But imagine that the club is a bit struggling. They need for other investments those monies. So there's some fund investments. There's some banks, several financial institutions that say, "Hey, you don't have the money, but I could factor you. I could anticipate those installments with a price, of course, but I anticipate you that, and that allows you to have a better liquidity situation." This is something that you do with the transfer fees, but not only with the transfer fees, you do it as well on the broadcasting side as an IPS. Okay, I got 2 slides of risk and mitigation more onto the transfer agreement side that I give you as an ancillary, but I'd like to create to analyze after COVID-19 risk and mitigation plans and adjustment. What does it mean? That means, what do you think in the sports industry? We were talking about ticketing, impact even in broadcasting. What do you think the different competitions, the different stakeholders in the industry try to alleviate or try to manage that risk and how they mitigate it? And that could be a good start for discussion. Let me wrap it up saying that in terms of image rights, I forget to tell you that in this current season, NCAA, which is the US university basketball competition, the players, the athletes, were not allowed to obtain fees for seizing their image rights. Right now, starting from that season, this is recognized. It makes a way to get extra revenue for them. This is another step forward for the business, and that underlines how important IP rights in the sports industry. Even for the youngsters, for the young players that are starting a big title competition like NCAA, has a huge impact. And in this COVID-19 situation, the NCAA realized that it was important to get a piece of that cake as well for the main characters of the competition, which are. So closing that bracket and going back to the discussion, what do you think in terms of risk and mitigation on the sports industry could be a good plan or something that has been done? Or what do you think? What type of policies have been applied to mitigate those plans? What do you think? What have you read in the papers or in the in the different social networks that you follow or you've heard on the news or whatever. Go
I have a question about your last point on the NCAA. So,
Yeah, go
is the money that the players are making now, does the NCAA benefit from that too? Do they profit?
Yeah, of
from
course. The thing was that they had a direct impact on the sponsors and on the
Right.
competition itself, and the athletes didn't get a fee out of that, and they were the main characters. They were the ones that produced or produced the show, let's say. And they were complaining for the past years, and they said, well, we want a piece of the cake as well. And from that season 21-22, they started to get that proportion. They were young athletes in the university. They knew that most of them ended up in the NBA probably, and they were playing about, well, you're young and you will have time, but they are exposing, and some of the players are quite, they have a significant tracking and reputation. They are followed on their social media channels and on TV. So I would say that NBA, it's a top league in terms of basketball worldwide, but NCAA could be, obviously, EuroLeague, maybe it's a step forward, but it's playing, I mean, it has a good, a significant impact, even worldwide. Obviously in the US market, but not all the US, and it has a variety of number of followers, very easy. So any ideas? We've still got more or less 5 minutes. Any policies that you think, or anything that you've heard about how to mitigate? Because, I mean, we could go a little bit more into detail of those risk and mitigation, but I think that it's very, if you think about some policies or something that you've heard.
For example, stadiums.
What, the stage?
The stadiums.
The stadiums.
They're going to
Renew.
yeah.
Well, Real Madrid, for instance, is renewing the stadium, and now that was actually to get. It is related to COVID, and not. Real Madrid saw the opportunity, and not only Real Madrid, other top football clubs realized that match day gives you a certain number of revenue streams. But football is not only match day revenue. This is something that in NBA and other US markets they realize earlier. The thing is, what happens in the different arenas, the stadium, etc., training, competition. If you only utilize that venue for the event itself, for the match day, you're losing a huge number of opportunities to get extra revenue. For instance, Bernabeu now will have the opportunity to have concerts much more often than it used to, and you'll have a system whereby it'll be easier to celebrate those matches. Now, in Metropolitan in Madrid, FC Barcelona, let's hope that they will have money to renew the stadium. But that could be an option. But not only that, we're talking about, and we didn't go so much into detail on those, but I'm sure you've heard about introducing, once you're watching the game, introducing different apps where you can buy, you purchase, and you get whatever food or beverage where you sit at the stadium. That could be an option for the cashless system. I mean, other types of fun and entertainment, commercial around the stadium or the arena. So there's many options that will help to get extra revenue. Some of these options during the COVID were a bit difficult, but all that are related to digital or what my friend Carlos Canto renamed as physical, which is a mix of physical and digital. This is something that, that certainly had an impact during that pandemic here now that we're in, and will have an evolution on the next. Yeah. Okay, we've got a question.
No, that was me.
Oh,
Writing on the group.
So, any other policy or ideas or something that you've heard? I mean, there's the record of temporary employment that are applying to the football as well. Now other industries like clubs have asked for that, those for loafing. For certain employees on the club, but certainly if you don't have the athletes or the footballers, we're talking about football, right? If you don't have the footballers in your squad, it's difficult to play the game. But certainly there were some discussions about how to maintain squads, top clubs at those level of salaries. And this is why clubs ask for some how to construct early termination during the public period. Sponsorship agreements were reduced, but there was this combination of if I cancel the agreement, maybe that will be affected on the brand perspective, and maybe open see. Reputationally wise, it could be seen as a bad movement. So let's try to be stable on the partnership side from the club and the brand. So, and I will get much extended. I will try to finalize if it will go right.
I was wondering, just a minor question, you were saying now about restructuring of the contracts of players. To what extent does not Article 41 of the Spanish labor law already comply with that and generate framework for them to be able to renegotiate those contracts?
Yeah, well, actually, under the temporary record, there has the Spanish Federation actually was against the labor regulation of Spain, and they were saying, I mean, there's an extension of the season because of COVID restriction, and this is how it is. But the players, they had to go under the labor laws, and if the contracts terminated on 30th of June 2020, they could force them onto that position. But obviously, there was force majeure reasons, and this is why, in the end, all parties tried to get into a satisfactory agreement, because they were not only the parties between club and the athletes that were implied into that relationship. There were other stakeholders in the industry that they could be affected if that specific player didn't want to play for the games after that termination. So in the end, they could come up with that idea, but that was certainly something that was put under the debate, and certainly was one of the points where the athletes defended as well. We have to be compensated somehow, and then the problem was more onto the club side, where they have less revenues to pay the salaries for the defense. And but that's a good call, and certainly that was one of the points that the collective agreements represented on the ability or not on paying the salaries of the different players, and how the different footballers or other athletes could play after the extension of those agreements that finalized or terminated on the 30th of June. And last point that I wanted to raise is that right now you've heard that the US was trying to waiving the patent of the different vaccines for COVID-19 in different areas like Asia, different countries such as India. Even this might go against the protection of the IP itself. You have to, this is a very good representation of the importance of the IP worldwide, because it's obviously a transfer of knowledge and it has to have some sort of protection. But in the end, you have to balance it in this case, transfer of knowledge between transfer of knowledge and global health and safety worldwide, because probably if you were reducing that in that area, the implication that it has in terms of the safety of more people getting with COVID-19 in that area could produce more escalated pandemic and could interfere on the global health. So, having said that, and if there's no more questions, thank you very much. Sorry if I would have liked that you could interact a little bit more, but I hope you had that you thought that the topic was interesting and and that you enjoyed the time. And a pleasure.